Hi, everyone. Thank you so much for joining us today. Welcome to Coast Legal Aid of South Florida's Mediation 101 Clinic. This panel will be moderated by myself, Mia Stevenson, Sophia Katash, and April Fieser. This panel brings together three distinguished legal professionals, Brittany Simpson Joseph, Louis Reinstein, and Mimi Turin. Each of them offer unique perspectives from their extensive experience in litigation and mediation. Through an interactive discussion, the panelists will explore key strategies for effective mediation advocacy, the role of the mediator, ethical considerations, and tips for preparing clients to achieve the best possible outcomes. Whether you're a seasoned litigator or new to alternative dispute resolution, this session will provide valuable tools to enhance your mediation practice.
Good afternoon, everyone. My name is Sophia Katash, and I'm excited to welcome you to today's Mediation 101 Clinic. We are fortunate to be joined by three outstanding panelists, each bringing deep experience in mediation, arbitration, and public service. I would like to begin by introducing our first panelist, Louis Reinstein. Louis Reinstein is a Florida attorney, mediator, elected official, and corporate representative with nearly 20 years of experience in litigation, appellate advocacy, and public service. He currently serves as legal counsel to the Broward County Legislative Delegation and as Plantation City Council member. In the private sector, he works as a corporate representative for Frontline Insurance and conducts remote civil mediation statewide through his practice, Louis Reinstein, PLLC, as a Florida Supreme Court certified county and circuit court mediator. Previously, Mr. Reinstein spent over 15 years at firms like Kelly Cronenberg and Billing, Cochran, Lyles, Mauro, and Ramsey, where he handled high-stakes litigation in civil rights, medical malpractice, commercial disputes, and municipal defense. His commitment to public service also includes his role on the board of directors for Coast to Coast Legal Aid of South Florida since 2021. Mr. Reinstein holds a JD from Nova Southeastern University and an MA from Emory University, as well as a BA from the University of Florida. Next, I'm pleased to introduce Brittany Simpson Joseph, Director of the 17th Judicial Circuit's Court Mediation and Arbitration Program. Brittany Simpson Joseph became involved with the courts in 2012 as a volunteer guardian ad litem. Ms. Joseph maintained her involvement in the legal system in guardian ad litem roles that focus on the best interests of the children. In 2017, Ms. Joseph became a Florida Supreme Court certified family and county mediator, a role that she maintained until 2021 when she was selected to be director of the 17th Judicial Circuit Court's Mediation and Arbitration Program. As the director, Ms. Joseph oversees the Alternative Dispute Resolution Program, including all mediation and arbitration. Ms. Joseph maintains her mediation certification and continues to provide court mediation services to qualifying individuals when her schedule allows. Most recently, Ms. Joseph was appointed to the State Committee on Alternative Dispute Resolution Rules and Policy. This committee reviews all of the governing rules for court-appointed mediators, and Ms. Joseph will contribute her thoughts on potential updates to the rules in pending cases. And finally, we're so glad to welcome Mimi Turin, a highly experienced mediator, arbitrator, and founder of the Turin Center for Dispute Resolution. Mimi Turin is a business owner and third-party neutral at the Turin Center of Dispute Resolution. She also serves as an arbitrator at Financial Industry Regulatory Authority, American Arbitration Association, and the Better Business Bureau, where she handles employment and consumer panels, financial industry claims, motor vehicle claims, and class action appeals. Ms. Turin's previous practice centered largely around labor and employment defense litigation, along with local government issues for over 2 decades. In this capacity, Ms. Turin represented the City of Miami, City of Hialeah, and the Office of the Florida Attorney General. More recently, she served as special counsel to the Civil Service Board of the City of Fort Lauderdale. Ms. Turin's specialization in government law allows her to bring a unique perspective to her work as a certified mediator and arbitrator. She holds a JD from the University of Miami School of Law, along with an MS and 2 BAs from St. Thomas University. In her free time, she enjoys volunteering for her local Humane Society and helping with genealogical research. We are truly grateful to each one of you for being here today and taking the time to share your experiences and insight with us. With that, I'll go ahead and turn it back over to April, who will begin the discussion portion of today's program.
Hi again, everyone. Just to welcome you and get started with the discussion portion, I'll ask some general questions about mediation. Before we get into court versus private mediations, can you briefly address the benefits of taking a case to mediation?
Sure, I'm happy to go ahead and start. Again, thank you for the opportunity to be on this wonderful panel today. And Coast to Coast Legal Aid does some amazing things for our community. So thank you. So the number one point that I always like to make for mediation is that it's an opportunity for the parties to really put an end to their litigation, and it's in their hands. And when they understand that we're not there as mediators to force anything upon them, and to the exact contrary is that they have to accept it. It's up to them, and we're not. We may be trying to direct them in a certain way, in a way to assist them to understand the process, but making sure that they fully understand that it's in their hands, and this is a way to put an end to the litigation. And as much as they may love their attorneys, I'm sure they'd be happy to stop paying them. So that's one thing to really make clear at the outset, that it's in the parties' hands.
I could also add something to that, which is oftentimes people don't realize that when you're actually in litigation, uh, the Florida courts, is just like courts in any other jurisdiction, are often quite overburdened. And people don't realize that it might take you a couple of years to actually get to that point of finality where you can finally be done with it, walk away, and resume your life. Mediation, arbitration, they put more power in the parties' hands, but it also allows them a more efficient and more cost-effective avenues to obtain their remedy and to get on with things. Usually you can get to arbitration within less than a year, and mediation you can usually schedule very quickly. Whereas if you're waiting for a trial date for a jury trial in Florida, sometimes that can last up to 2 years.
Shifting gears a little bit, what is your goal as a mediator to help the clients with their issue?
Well, I can address this one. So I think our number one goal is to empower the parties to make their own decisions and exercise their self-determination. Um, because as Lewis and Mimi said, the court process can be quite long. So if we can help them make their own decisions, that helps with the court process, that helps speed up things, that helps with costs, but it also creates an agreement that they may be more likely to follow.
Yeah, and I'll add to that. I mean, Brittany is spot on that the word empowerment is key. It's really about the parties coming to the resolution themselves, and understanding that they both probably aren't getting exactly both sides probably aren't getting exactly what they wanted. And one is probably giving up more than they wanted, and the other is probably taking more than or taking less than they wanted. But in the end, they will swallow it a lot easier because they came to those conclusions themselves, instead of a third party, whether a judge or jury, making that decision for them.
Thank you. Is it your role to prevent the parties from reaching an impasse, or is that something that you're just considering or having a discussion with the parties?
So I could address this one. No, it's not our role to prevent an impasse. There's a lot of movement that can still take place, even when an impasse happens, even though as mediators, we're bound to only report the final outcome. So if they sign an agreement, we can report that. But there's a lot of moving parts in mediation. So there's a lot of conversations that take place that help the parties in the right direction. And they may revisit mediation at a different point, or a settlement conference at a different point. So the point is to create some movement for the parties toward resolution, even if that ends in an official impasse on the first try.
Yeah, and I can also add that impasse is not a bad thing. Sometimes it's the right thing, and sometimes coming to that conclusion sooner rather than later is better for the parties. We're not there to drag this on and make this an uncomfortable opportunity. This is an opportunity for the parties, and if they're not ready and willing to take it, sometimes there's nothing that we can do about it. And sometimes impasse is the right result, and sometimes it happens quicker rather than being dragged on.
Absolutely. And Louis, you touched on this a little bit, but if there are any other, common misconceptions about alternative dispute resolution or mediation in general that you experience?
Yeah, first of all, I'm never a big fan of using the word alternative. It's, we when we talk about mediation, it falls under the rubric of alternative dispute resolution, but it's really not an alternative anymore. It's part of the dispute resolution process. It's part of the litigation, and sometimes. Sometimes at least as far as mediation, sometimes it's a learning experience. Sometimes the parties we know really are very unlikely to come to a settlement during that mediation, but sometimes they really just have to hear from each other and need to hear from a third party. I find that oftentimes the party is not listening to their own attorney, and hearing from somebody else is really helpful. And I think the best way to really attack some mediations is to have a really frank and honest conversation with the counsel in advance. And if you learn from the attorneys that are involved in the process as to what they expect and how they think it's best to handle their own clients, sometimes that's the best way to really help the parties find a resolution.
Thank you. Ms. Turin, you serve as a third-party neutral in a few different ways. Can you please tell us how arbitration and mediation differ?
Sure. When I'm serving as a mediator, it's more of a facilitative process, and you're helping the parties to communicate effectively to hopefully reach a resolution or some kind of closure. So you're there not as a decision maker, but rather to help them communicate. When I'm serving, though, as an arbitrator, it is adversarial because I am there as a decision maker. It might be binding on the parties, my decision, or it might be non-binding, but nonetheless, it gives them an idea at the end when they when they read my decision as to how a neutral third party has reviewed and evaluated their arguments and their evidence. So yes, there is quite a difference because I'm not facilitating as an arbitrator. I'm going to be making a decision, and one side will be happy and one side will not be.
Thank you. I know sometimes during a mediation, you'll have clients go to a breakout room or a caucus room. What does that mean? What does that process look like?
I can go ahead and answer that. Most of my mediations are going to be electronically by Zoom. And what that means is we take each party, put them in their own separate room. And sometimes we even start out that way if there's a lot of animosity or emotional issues in a case. And in that capacity, they can discuss things privately with the mediator, who can then take whatever information is authorized back to the other side. So if it's an in-person mediation, you'll literally have two separate rooms for the parties where they can be privately meeting with the mediator and have that level of confidence that they're not necessarily staring in the face of their opponent and that they can communicate more openly about their concerns or what they want to accomplish.
Yeah, and the breakout rooms really are the same as they would be if you were meeting in person. So just as Mimi has described, is that, it's no different in to the extent that we're just separating the parties and having private conversations with them. You know, when it used to be where you'd have to open a door, a hard door to walk in. Here it's a digital door, right? And it works exactly the same way. Really the only difference that I find often is that, when you're meeting with them in the Zoom breakout rooms, you need to really make sure that you have their full attention. When you were in a room in a building and you were sitting at a table with somebody, you could see exactly what they have in front of them, what they have next to them, behind them. If they're looking at their phone, you can see it clearly when you were in person. None of that is as clear when you're in the Zoom breakout rooms, other than you're watching their eyes and you're watching where they're looking, and any delays in terms of how they're responding. And having those conversations also at the outset are really important when setting the tone and setting the framework or the rules for Zoom mediation. Making sure that everybody knows that there's no recordings allowed, whether audio or video recordings. Making sure that everybody understands that if they need to talk to somebody because somebody has walked in the room, we can take a break. We can stop for a moment. And we'd much rather that, and make sure that we have everybody's full attention than the alternative.
I know that you mentioned some strategies for particularly adversarial parties, like keeping them separate so you can chat with them. Are there any other strategies you all like to implement to, at least come to some resolution or some common ground when the parties really just are not getting along?
One of the things that when we're talking about using Zoom, and even right now, you could see that we don't have the full image of everybody, and so seeing people's body movements, and do they want to talk, or are they waiting for somebody else to speak? And sometimes it really is just being hypersensitive and alert to everything that's going on in the different Zoom boxes that are in front of you. And, I try not to use the mute button, right? If people want to be unmuted throughout the mediation when we're meeting together, I don't necessarily mute them unless I think I have to. And I let people know that, we're here to show respect to everybody and give everybody a full opportunity to speak. And I actually always, when there are lawyers in the Zoom mediation, and they're there with their clients or their representative, I always ask whether the client or the representative wants to speak. And I know that 90% of the time they won't speak. They're happy to let their attorney speak for them. But it goes back to Brittany's comment about empowering, right? Is that when sometimes they do want to speak, and then the key is to make sure that the other side is being respectful in how they're being presented on the screen, right? Because the rolling the eyes or the verbal outbursts are not helpful. And so being alert to all of that is part of the Zoom mediation that we have to really be attuned to.
Thank you so much. We're going to next briefly discuss court mediation, which I feel particularly lucky to have observed a few. So I wanted to start off with asking how a case gets sent to court mediation, just so we can just start from the beginning there.
So for court mediation, you need an order of referral from the judge. We can't take cases that come in from individual parties. It has to be referred by the judge. But there is an administrative order in place that mandates all cases to go to mediation prior to moving forward, all family cases, county as well, unless there are some exceptions to that. There are some cases that are not meant for mediation, but most of them go to mediation prior to being scheduled for trial.
So it sounds like a judge plays a really big role in deciding what goes to mediation outside of those administrative orders determining what goes to mediation. Why does a judge typically make that case specifically go to mediation?
So it helps with their case count, of course, but also there are a lot of things that can be resolved without the judge having to decide for the parties. I've talked to our chair and our administrative judge for family, and they want people to make their own decisions and decide their own cases, because especially when dealing in family cases, it's better when parents are able to create their own schedules if they're able to do that. That's not always the case. Sometimes you need a little help with that and they need a trial, and they need more, assistance making that parenting plan. But if parties are able to create their own plan, the courts prefer them to do that.
And
It sounds like,
oh,
sorry, go ahead.
let me add to that the similar process applies even in the arbitration format. When I'm serving as an arbitrator with parties and I have that initial conference to schedule deadlines, get an overview, what's outstanding, and so on, one of the first things I'm going to speak with them about is, have you gone to mediation? If not, I'm setting a deadline. You need to do that. Because again, as Brittany said, it allows the parties to fashion something amongst themselves that's workable for both sides. So I would rather, and I think they would rather economically, to reach that point sooner in the process than to wait until I'm on a plane flying out to wherever they are, getting there, and then they tell me, oh, we've resolved it. Okay, so it's added to the cost, it's added to the time. Whereas if they can come to something that they both can agree to much earlier, everybody gets to move on with their lives. I mean, I do have an expression on one of my calendars that says, we want to move party to closures, because once you get to closure, people can move on better with their lives, put this in the past, and just move forward.
Yeah, and that comment about moving to closure is that when the parties are moving themselves to closure as opposed to somebody dictating closure for them, it's a lot easier for them to digest it and to really
Exactly.
move on from that litigation and from that period in their life because they helped create the closure as opposed to again a judge or a jury. And also, just as has been described, is that the courts are overwhelmed. The dockets are huge, and mediation and arbitration, these are now part of the process, which is again why they're not alternative. They're part of the process. And sometimes we find that adversaries, the plaintiff and the defendant, they've never spoken, and so the mere interaction will sometimes put an end to a dispute very quickly, because that's all they needed was to be brought together, and the mediation affords that opportunity.
Absolutely. And to piggyback off of that, even if we don't have a full resolution and we have a partial one, that still will minimize the amount of docket time they would take, an amount of time that they would need to spend in front of the judge and the amount of issues that the judge needs to decide. And even if it's partial, like Lewis said, I absolutely agree. If the parties make that decision, that leads them closer to the closure and helps with eliminating some of the returns to court when they're making their own decisions.
Additional qualifications for parties to go to court mediation outside of being referred by a judge?
Yes, so court mediation programs across the state are mandated and governed by a Supreme Court administrative order that governs the amount of cases, the income of parties that we're able to take. So currently, and this is about to change soon, there's currently some proposals to change the dollar amounts to meet the current economy. But currently, for family cases, the combined income of the parties has to be under 100,000. For county cases, court mediation programs can only take cases up to 15,000 in claim amount, and dependency cases, we take all of those. We cannot take circuit civil cases at this point because their dollar amounts would be much higher. So that limits the amount of people that we're able to provide our services to, but it's still quite a lot of people. Those amounts that are subject to change are not finalized yet, but it would encompass a greater amount of people, and allow us to offer services to more people in more cases.
It does sound like court mediation provides people who may not have access to private mediation with really this opportunity to still go to mediation, even if they can't afford to go to a private mediator.
Absolutely. It's a very different process than private mediation, but it still has its place. My goal as director is to provide quality mediation services to people who wouldn't be able to afford it otherwise. So even though we're dealing with maybe not as many assets as those who would be going to private mediation and things like that, we're still dealing with complex issues involving families, residential evictions. We deal with a large quantity and spectrum of cases. Um, but we're really here to provide a service. So even though we're limited in time to how much time we can dedicate to each case, we really try to give people an individual experience.
Thank you so much. So we wanted to ask, how do you think that mediation differs when it's applied to family law cases when it's compared to other court cases? We've discussed a little bit how the cases that court mediation is seeing they're so complex. There's a lot of complex family law issues, and you're also able to see a lot of other types of cases that are more county level cases, a little bit not lower stakes, because I think that any court case is high stakes for the parties involved, but they're just different types of issues. So how did those mediations differ?
So the concept of mediation, it's the same across any type of certification that you would get. I'm certified in family dependency and county, so the same concepts apply to each type of mediation that I do, but the issues are different. So when you're doing a family law case or a dependency case, you're dealing with a lot of emotion, and you're dealing with people and children, and that's complicated. And when you're doing a divorce, you're unraveling a life that someone is used to and trying to figure out how people are going to move on. So there's an elevated amount of emotion in those cases. But I also surprisingly find the same thing in county cases. When we're dealing in consumer cases, which are credit card cases, you're dealing with people who can't afford their bills, so they're in really dire straits when they come to us. So there is a level of emotion, I think, in all facets of all types of different mediation, but I think it's just the amount of issues that you're dealing with. For court mediation, anyways, I know there are some more complex cases, but in county, you're usually dealing with one or two issues at a time versus a family case where you're dealing with hundreds of issues going on at a time. So I think that's the difference, is just you're trying to weave things together in a different way.
Thank you so much. So we talked a little bit about how not every mediation is the same, but mediation as a concept applies broadly across a wide variety of issues that it can be applied to. Can you walk us through what a court mediation typically looks like, and acknowledging that that might be a broad question?
Sure. So, okay, so for family mediations, most of those occur on Zoom. We will accommodate and have people in office if that's requested by the judge or by the parties. Sometimes people are unable to use technology, and we have some computers available, and we'll sometimes just bring everyone in person if that works better for everyone. But mostly family is on Zoom. County, small claims, those are instant mediations for the most part, where you have mediators in the courtroom there on those cases. County, those are pre-scheduled, and there's a mix depending on what the judge wants to do, whether they're in person or Zoom. We adhere to the court order. But what that looks like when the parties come to see us is essentially the same. So we'll do a short introduction of just everyone in the room, and then an orientation session where the mediator goes through the rules of mediation and gets people familiar with the process. And then we'll start with the petitioner or plaintiff, allow them to share their goals and what they would like to do, and then allow the respondent or defendant to do the same. And then there's just a lot of back and forth after that. Depending on the case, we may start together, we may start separately. It's really up to the comfort level of the parties. We adjust and we're flexible to what the parties need.
Thank you. And do you have any tips for preparing for a court mediation?
So, as much information as you have, it would be nice for folks to bring that. We do understand we deal with a lot of unrepresented individuals who have never been through the court process before. So, we will work with you. So, don't worry about showing up unprepared. We will help you and try to figure out what you would like to do. And we can also adjourn and go into second sessions if we really need to stop and get some more information. But it is helpful to come prepared with at least an outline of what you might like, and also with an open mind, and be a bit flexible of what the other party might want to do.
Thank you. And then I just have one last question. We work at Coast to Coast Legal Aid with a lot of victims of domestic violence. So sometimes there's a injunction for protection in place against domestic violence, even when they're going to mediation. Can you talk a little bit about how that affects a mediation?
Absolutely. So for cases where there's an injunction or simply where someone is just afraid of the other person, we will separate the parties as long as we're made aware. And most of those cases we can see that there's an injunction in place, but sometimes there's one that's confidential within the docket that we can't see. So we do ask that if you are coming to mediation, that you call our office and let us know ahead of time that you want to be separated from the other party. And we will have you separate from the start. We won't even do the orientation session together. And I think the most important part of that is just to try to take a deep breath and trust in the process, because remember, with mediation, the parties are the decision makers. The mediator is not there to ever make anyone do anything that they don't want to do. So everyone has the power in that situation. If you're uncomfortable, to go ahead and say no to something, that's okay. And it might be a slower process that we have when there's cases of domestic violence. But when we're in separate session, the process itself is not much different. We're just a little sensitive to specific issues and concerns that individuals might have for safety concerns, such as drop off, pickup, those types of things. And as long as you communicate that to your mediator, we're used to dealing with those cases, and we're there to help.
Sorry about that. Thank you everyone for your responses this far. For our third topic, we're going to discuss private mediation. Louis or Mimi, how does a case typically end up with you as a private mediator?
Okay, I can start with that. Actually, most of my mediations are referred by agencies that I do work with. So it could be legal aid, it could be the Florida Bar, it could be any of the consumer agencies I work with, such as the BBB, National Center for Dispute Settlement, AAA, or FINRA. And generally, they will just reach out. They'll provide a brief overview of the case to check for any conflicts or any information that way, and ask about availability.
And for me, many of mine are through orders from the court, where I'm suggested as the mediator. And usually, what I find is that that I then will hear directly from those counsel that they found that they enjoyed the process and they thought that we worked well together. And so then they'll come back, kind of like repeat, like repeat clients, so to speak. And I don't do any any true advertising, and I don't really do any advertisements in any magazines or anywhere else. You'd find it listed on my LinkedIn profile, right? But other than that, it's a lot of word of mouth, and that really has been the best way to make sure that that the right matters, the right parties, and that we can all be successful together.
Great. And then once you have been brought into a case, how do you go about preparing, especially when you don't have all of the facts up front?
Yeah, that's a really good question. And, sometimes I find that the attorneys for, in particular matters, they don't provide me next to anything, next to nothing, right? Is that they don't send the mediation, summary in advance. They don't suggest, what they would like me to look at. Sometimes I'll get a copy of a motion for summary judgment. Sometimes it's just a complaint and an answer. And again, sometimes it's nothing. And, I really find that I like to at least review the docket and get a sense for myself, even if the parties aren't providing me anything. And then it helps me come in with a little more insight. And, then, I'm able to also say to the parties, oh, I see that something is pending, or I see that this is, you've been in this for a really long time. And so even though when counsel for the parties may not be providing me that information, looking it up and just doing at least a little bit of review of the docket and looking at, what kind of motion practice has already taken place, I find that helpful to assist the parties.
Great. And
And
for someone,
as Lewis said, I kind of do the same thing. I'll ask them either for a summary or send me a copy of a pleading. If you have a pending motion, I'll also check the docket just to get an idea of where they are and what some of the issues are outstanding and maybe who's been more aggressive in the litigation, because sometimes you can tell that from the documentation or see what's outstanding.
and for someone who is going to mediation without an attorney, what would you recommend they do to prepare and make sure that their voice is heard?
I think as Brittany kind of pointed out earlier, tell them to read the papers, not just your own papers, but anything filed by the other side. Educate yourself on who's asking for what. What is it that you want? That party is going to know what they want generally, but look at what the other side wants and go in with an open mind. Also, try to get a good night's sleep. Go in as refreshed and open-minded as you can, and just go in as prepared as you can be. And that starts with your homework, which is reading your own papers and those of the other side.
Yeah, and Mimi makes a really good point. But the flip side of that is that there's really not much some of the unrepresented parties can do other than show up, right? Is that part of I see as part of our responsibility as mediators is to be aware that that unrepresented person, this is their first interaction oftentimes with the law and with a mediation for sure. And so really just remembering that sometimes we need to explain the process, for the first time to somebody. And, even though we may have gone through it so many times as lawyers or as mediators, and we know that maybe there's counsel on the other side that doesn't need to hear the instructions, we give them anyway so that they hear it from us and everybody's hearing the same thing. And sometimes when we get into those private breakout rooms, we're really spending more time with that unrepresented person to make sure that they are fully feel as if they're being heard and fully feel as if, they are getting their, that expression, their day in court, right? Is that, instead it's their day in the process. And, if they don't fully understand that, then they're never going to be content with finding a resolution because they don't understand what it means to find a resolution in the mediation process. And so, really just being open to each each party differently and separately, and really nailing whether that individual that's unrepresented needs some more, tenderness, right? Needs some more, love and attention. You have to be prepared for that if you want them to be able to feel good about the process.
And piggybacking on that, if one party is dissatisfied with the proposed settlement offer, is there any pressure for them to settle or accept? How do you typically navigate that situation as a mediator?
Yeah, the idea of pressure is a tricky one, right? Because on one hand, I don't want to put any pressure on the parties. I want them to feel their own internal pressure because they realize that they're spending a lot of money on the litigation, they're spending the money on the mediation, and they want to reduce the amount of time and energy that they're putting into the matter. And so I want them to feel their own pressure. I don't want to be putting the pressure on them. Sometimes I have to remind them that they have the power to reduce the pressure, right? And so it's really, putting those into terms and going back to, Brittany used it at the outset, empowerment. And so it's not about making them feel powerless. It's about making them feel empowered. And that means letting them know that they can reduce the pressure by coming to terms today. And, we often hear parties say that, well, it's not about the money, it's about the principle. And then when you say to them, okay, so we can take money off the table, we don't have to talk about any money. We can talk about just feeling, and then they always say, oh, no, no, of course it's about the money, right? And, I mean, that's part of getting them to understand that, the pressure's on them to come to help us find the resolution. Um, as a mediator, I don't find any pressure at all on myself because I know that it's in the hands of the parties, and that is as a mediator, that's very relieving, right? In terms of, but I still know that I have to make sure that they understand their role and understand the power that they have.
I
And
think
then
it's also really important to figure out why. I think, Lewis, you were just talking about this. Why is the answer no? Because sometimes it's so simple, where it's just, like Lewis said, a principled argument, or there's a slight variation that they want. And if you're just taking no at face value, you might miss an opportunity to bridge that gap a little bit.
great.
I'll just add to that one more point is that I think what you've also heard all of us implicitly say is that we can explore creative solutions as well, and that those are a little harder to come by when you're before the judge, and the judge has this very busy docket and is trying to move. He or she is trying to move real quickly through all the matters. When we're in mediation and we're listening real carefully to the parties, sometimes it's well, let me say this carefully, right? Is that I think it's always about the money, but on the other hand, is that sometimes there are other things involved too. And so, when you have those cases where there are family members involved and where there's, longtime best friends that have shared a business and, trying to sometimes get to the bottom of that or getting inside that is very difficult in the short time that we have. But when you let the parties understand that we can be creative too, that sometimes is what allows us to finish and get us to get us past the finish line.
Awesome. And then just lastly, to wrap things up, bring everything full circle. I know we touched on it a bit earlier, but is there anything that you guys personally find to be the most meaningful or impactful part of mediation or alternative dispute resolution, or anything we haven't discussed that you guys would like to touch on before we wrap up?
I think I'd like to just emphasize that regardless if it's mediation or arbitration, either process, it really puts the parties in the driver's seat. It allows them to get to closure much faster. It's a much more affordable process because you don't have all of it avoids all of the extensive arguments of the attorneys and discovery and so forth. But it allows them to see upfront and personal that justice is an action. If it's mediation, they're part of the process. If it's arbitration, they're part of it. They're being heard. They're going to sit at the same table as the decision maker. It's not a box with 6 or 12 people looking at them with spectators in a courtroom. It's more private and intimate, and they can see it, and it's more hands-on and allows them to be involved.
I completely agree, Mimi. I think people have a certain idea sometimes of what their day in court will look like, and then are quite surprised when it's not like what's on TV. So please, I think we'd all urge you to take advantage of mediation and arbitration services so that you can make your own decisions and move to that closure, like Mimi said, quicker and much more cost effectively.
Mhm.
Yeah, I think they've really nailed that. Is that there's a lot of opportunities to resolve a matter through mediation and or arbitration, and knowing what the goals are in advance, knowing what the if there are attorneys that are involved, what they expect to happen is I think is very helpful. And if I had to give one request really to any attorneys watching this is that call your mediators in advance and or take their call and help them help you, right? Help them help your client find a resolution, and give us whatever insight that you can that will help us from the moment that Zoom is turned on and the moment we meet your clients. And same thing is that if there are clients of yours that are watching this that are not attorneys that are trying to understand the process, they're welcome to call us in advance too. And if they want to have a better understanding for the process in advance of turning on the Zoom, they're welcome to make that phone call too. And I welcome it because I think it helps all parties really get going and get deep into the matter from the moment that you get started.
Lewis, thank you for bringing that up. I know we deal with a lot of clients from legal aid as well. Please don't be afraid to call. You can call our office anytime. I believe you'll be provided the main line. And most of my administrative assistants who answer the phone are also certified mediators as well. So they have an understanding of the process, but you can also be directed to me if you have more specific questions.
Great. Well, that wraps up our conversation on private mediation. A big thank you to Lewis, Brittany, and Mimi for sharing their insights and experiences with that. April, I'll hand it back over to you.
A special thank you to all of our panelists for taking the time out of your busy schedules to chat with us. This was a great conversation on how mediation helps move litigation along, keep things efficient, and allow parties to feel empowered in concluding their own matters. Panelists, I'll give you each a moment to share any closing remarks you might have in no particular order.
Well, thank you for having all of us on, but I really especially love the opportunity to talk about the court mediation program a little bit more. Please call us. Our number is on the orders as well as the notices you get and in the emails that you get from us. You can email us, call us if you have questions, even if you have technology issues. Believe me, we're used to helping and we are here to help.
I would echo what Brittany just said. Thank you so much for having us. I'm a strong believer in education and offering information, and I think that this is, really a great public service because people do want to know and go into these proceedings prepared. So any kind of information like this, I think, will be very helpful to people who might otherwise be kind of intimidated going into a process that they're not familiar with. So thank you very much for doing this.
And I'll again add, thank you again for doing this, and it was really a pleasure to be speaking on this subject, and especially with Mimi and Brittany. And I'll just conclude by saying that when you're choosing a mediator, it's there's not one size fits all, and that there are different mediators with different styles, with different backgrounds, and just like when you're choosing a lawyer, or just like when I don't know, you're choosing what flavor of ice cream you want, right? Is that sometimes you have to try them, you have to have conversations, you need to really do a little research and realize that, if your mediation is not successful, there's no resolution, it doesn't mean that you can't have another mediation with another mediator. And likewise, you could have another mediation with the same mediator, right? If you feel that maybe you just weren't in the right place in the stage of the litigation for mediation to be successful, you can ask for you can set a second mediation. It doesn't need to be court ordered. The parties can agree to a mediation that's not court ordered. And so, I want people to understand is that that there are different styles and different personalities and different backgrounds, and don't feel as if that it was unsuccessful. Just feel like you didn't reach it just yet, and there's could be another opportunity.
Thank you all again. Your provided contact information will be displayed on the screen. If any viewers are interested in becoming panelists, our website will also be on the slide and you can place an inquiry there. As a reminder, this webinar is CLE eligible. The CLE code is 2507666 and the letter N. We hope this information was helpful to better understand mediation and the approach mediators take to problem solving. Thank you all and have a great day.
Thank
Bye-bye.
you.
Thank you.